So we rented the house, and there were certain issues that needed to be fixed, like some cracked windows, some plumbing issues, things like that. So we trusted that the work would get done. The work wasn't getting done, so when we started doing it ourselves, we kept receipts and started deducting, giving him the receipts and deducting rent from the receipts. Well, that kind of started stirring problems. The issues started getting bigger and bigger with, like gas leaks and major water leaks and leaks in the roof. The leaks in the roof was the final one. So at that point, we left. We left the house. We informed the landlord that we were leaving, why we couldn't stay in the house, what was going on. And he basically said, well, then I'm not fixing anything. I'm ending your lease. And then we were looking for a place to live or somewhere to store our belongings, and we couldn't find in a matter of time. And he calls us one evening and says, I've changed the locks. You can't have anything until you pay me such and such dollars. When we heard about it, I was absolutely furious. Everything that we owned was there. At that point, I was like, all right, I can't file a petition on my own because I don't know how to write it by myself. So that's when, I was like, look, we need an attorney. And my biggest fear is that I would call Neighborhood Legal Service and they'd say, we don't deal with that. But I was very happy to find out that they do deal with it, and I was here and they could help us. After everything was done, it was a big relief, huge relief. At least I knew at that point, okay, we're done with this. We can move on. We can save money. We can move on. We can look for, a new house and start over.
An illegal lockout is when the landlord takes action on his own without use of the law and the judicial process. The Pennsylvania legislature has set up a procedure whereby a landlord who wants possession or who is owed rent can go to court in a fairly simplified procedure and have his or her case heard before, first of all, a district magistrate judge, and get a decision very quickly. But what happens is that many landlords who are not very sophisticated and frankly are not, haven't educated themselves, because this is a business and you need to know the rules. They haven't educated themselves. They get into this business and they think that they can do just whatever they want. And an illegal lockout is when they take matters into their own hands, and by shutting off the utilities or padlocking the door, sometimes they've even nailed the door shut to the house, or come in while the tenant is away and put all of their personal goods out on the curb and then lock the door. That's what an illegal lockout is. In a lawful eviction, a tenant knows that the landlord is moving against them because they must be personally served with a paper which is an alert that there is a case being filed against them, either personally served or the notice posted on the door that they are going to be in court and given a day in which to appear and to plead their side of the case. And that's in front of a district magistrate judge. When a tenant is illegally locked out, the tenant needs to get legal help immediately because, as we said, that's illegal. And so there are remedies that the law affords a person in that situation. And generally what's done is that a lawyer can bring a complaint and ask for a preliminary injunction to have the tenant put back in the residence. And if there's damage done, they can ask for damages in their complaint. It used to be that when a landlord was owed rent or claimed damages, he could what was called distrain personally on the tenant's personal property. Pennsylvania did away with that. And there are a series of cases that say that it was simply unconstitutional to give the landlord that kind of power without the landlord first going to court and getting a judgment. In other words, a third party, that's being the judge, saying that you have a legitimate claim and I'm going to award you damages as a result of that. But also giving the tenant an opportunity to say why the landlord might be wrong. That's what American justice is about, giving both sides an opportunity to be heard and having a disinterested third party make a decision. If the tenant thinks that the landlord still has the property, we can go back to that preliminary injunction and complaint, claiming that the landlord has trespassed illegally on the property or converted it to his or her own use. Those are terms, legal terms that the law has, and seek damages. The other thing that the tenant can do is file an action which is called replevin, legal term, to get the property back. But again, to seek damages, because the landlord is obliged under Pennsylvania law to get a judgment and then to follow the proper procedures. You can't just have a judgment, but then they have to ask for an order of execution, and then on the basis of that order of execution, a constable or a sheriff goes out and then performs what's called a levy. In other words, exercises control and an inventory over the personal property that is going to be sold at a sheriff's sale or a constable sale in order to satisfy the judgment. So at several steps along the way, the tenant is afforded legal protection and has recourse, has things that they can do to save their personal property.